Hello and welcome today in our talk. Today we have Advocate Govind Bali sir with us, and we are going to deal with the legal matter which is stirring up debates in the current issue, which is should 3 years of practice at the bar be mandatory before someone can enter judicial services? First of all, we would like to hear from you, sir, your point of view regarding this judgment of the Supreme Court.
See, basically, for me, it is a positive step towards improving the judicial services
Right.
because people backed with some experience and seeing the side of the bar would understand what are the practical difficulties in processing a case. There are certain things which cannot happen in a day. You cannot learn the nitty-gritties of the profession just by clearing an exam. That is the larger sentiment. For people who are practicing at the bar also believe in the similar way. Certainly, yes, there are certain apprehensions to it that the age limit will not be increased. There might be some issue with respect to the number of vacancies being fulfilled. But if we go by the statistics, even today, if a person is not getting qualified in the first attempt of judiciary,
Right.
it is generally taking him 2 to 3 years to clear the exam. What is the hype about? The hype is that that person now has to be registered with the bar. The hype is that person has to go to the court and see the procedures ongoing rather than just sitting in the coaching rooms and learning the theoretical part of it.
Right.
So the positive part is about the practical implication of it. How practically you're making people judicially, having the judicial acumen to deal with things.
Right. So, of course, there are point of view from the judiciary. Of course, for the judiciary, it is a good step that has been taken in the judicial services. But if we consider from the aspirants' point of view, they certainly will not feel, appreciated about this particular judgment. There may be apprehensions regarding constitutional validity. For example, this judgment may violate some fundamental rights. For example, Article 14, Article 19, subclause 1, subclause G, as well as Article 21. So, how would you tackle these issues, and what are your point of views regarding this?
See, the largest court and the highest court dealing with constitutional matters, making a constitutional error is not an easy thing to believe. First, there is no violation of right to life here. Rather, it is safeguarding the right to life of many people at large and right to equality at large. The people who are becoming magistrates without any practice need to understand. You need to understand the fact that sitting on that chair holds a lot of responsibility. There are a lot of judges who are sent for retraining again and again by the courts. So, if there is a step towards the positive side of it, if it is improving, we should try and get into that. 20 years back, when the practice was not mandatory, made not mandatory, and it was actually mandatory to clear an exam, you had to have some practice. Things were better off. If they're feeling after 20 years of implementing that policy that it is not happening for the well-being of the society at large and the judicial system at large, there is some thought process behind it. And some people might say it is another way of increasing nepotism in the system. But how would the exam create nepotism is the question. The only thing is now you should look at the positive side of it. Now you get 3 years to prepare for an exam and then give it. Your chances of failure reduce.
Right, sir. But the reasoning behind this particular judgment of the Honorable Supreme Court was that the young law graduates were not experienced enough. So, what is the empirical evidence available that goes to show that they are inexperienced as compared to those who have practiced advocacy?
See, there's a lot of difference between clearing an exam and being a litigating lawyer. You might be one of the brightest students in your class. You might be getting 10 out of 10 CGPA in your law degree. That does not make you an experienced lawyer. Reading books does not make you a judge. See, you need to understand that how seeing both sides is important. When you see both sides of law, you understand how things have to be made out. When you see the practical ways how police is actually functioning, you will be able to judge in a better way because you've seen the flawlessness in the idea of justice. You're able to understand how the judges think and how the lawyer is going to think. You will be able to deliver in a better way. Now, whether there's empirical research on it or not, the answer is very simple. People are going for internships because they want certificates. Certificates do not call for experience, right?
It's
When you're talking about experience, even now there is no guarantee that these people who are going to be there, that this 3 years rule is going to make any big change with respect to the experience part. But yes, this was rather, people will think rather than staying empty for 3 years, we should at least go visit the court. Not 100% of them, maybe 20% of them will go into litigation and learn the nitty-gritties, which might improve the standards of judicial services at the lower level.
right, right. So at last, there are also some apprehensions regarding this, uh, dual jurisdiction. Basically, it falls within the jurisdiction, or sorry, not, but it concerns itself with the state list, and the state has autonomy to deciding on who should they be appointing, and they basically concerns themselves for the appointment in the judicial post in that particular state. Now, Supreme Court interfering into the matters of the state, is it right on the part of the Supreme Court?
See, state list is part of what? The Constitution. Constitutional interpretation comes under the ambit of the Supreme Court. With respect to the judicial system at large, appointments and salaries are a matter of state list,
Right.
not the procedure of selection. The exam system came into place, and every state has got an exam based out of which people are selected. But in the end, when the elevation takes place, there's a norm, no, that from the lower judiciary, certain seats are reserved for the higher judiciary, and then for certain quota seats are reserved for the high courts. Now, when the high courts come into place, one high court judge can be posted to any of the high courts. So you are dealing with a very mechanized thinking on it. The thinking is not just whether it is a state list matter or a concurrent list matter or a central list matter. The question is who is dealing with the idea of justice at large? Who is administrating the policies that are in place? If anything happens in the judicial system, the ambit is of the High Court of that particular state. The Chief Justice of the High Court comes under the Chief Justice of India, and the Chief Justice of India comes under the President. So there's a hierarchy in place. Now, just for the sake of argument, saying that no change can come into place, they have not mandated anything as of now. They have just stated that yes, exam should be there because some petition had gone there. They have not all of a sudden given a decision, okay, it is my suo motu decision that from tomorrow 3 years of practice is compulsory. It is a judgment and it becomes a precedent and it has to be followed. So the question of whether it is a state list matter or a concrete list matter or a central list matter does not matter.
Right.
What matters is how easily can this be implemented.
Okay. So, considering your take on it, if at all, aspirant or anyone who wants to challenge this judgment in the Supreme Court, what would be the procedure? What should be their approach to challenge this
See,
judgment?
basically, there must have been challenges already. When the petition had gone there, people must have already put their counters there, and then this decision has come into place. After this, the option is to go for a larger bench. And when the larger bench decides on it, then the things would happen in a different way. And it has to be a litigation of multiple people. One person is not going to fight it because you are challenging on what grounds? You are asking for a review or revision on what grounds? Would become the question at large. Because, see, if it has come till the Supreme Court, so it has taken some deliberation, no, to come
Right.
there. So the practical aspect of it is whether it has to be challenged or not, whether the courts find it claim worthy to be challenged, whether they're going to admit that challenge. So these questions have to be answered.
Right. Thank you, sir, for sharing such valuable insights with us, and we'll love to hear from you in further podcasts as well.
Okay.
Thank you.